Margaret, I think there's something that the interpreter wants to bring to my attention.
Pardon, my lord, at the date, 25th of April.
25 April.
Has he jumped that sentence?
Yes, my lord.
Yeah, because I read this motion.
My lord, try to bring to you.
Yeah, fine. I'm aware of
I
it.
think it should be March. Yes. I'm sorry. I'm sorry, on paragraph number 22, corrections. Paragraph 22, this aspect of the new evidence should also be factored in the preparations and be considered in the totality of the body of evidence led thus far to formulate the challenge to it. These new developments further compound and consternate the preparations in the matter.
Members of the bench, thank you so much for tuning in to my channel. I'm not a lawyer, but yeah, today Advocate MNISI really humbled the judge. He really did so brilliantly. Ignore him, dismiss him, hate him at your own peril. He is a brilliant legal mind, I must tell you. And yeah, as you can see, the way the judge is so impatient, very impatient. He didn't even listen to what the interpreter was saying. He's like dismissing the interpreter and like, I've read it. Batong. The case has been postponed for the 19th of May, and then on the 5th there will be a sitting, but that sitting is a progress report where Advocate MNISI will give the court on how far he is with the preparations. But again, he was already written off. He was labeled as unethical. He was, there were so many things that were said about him without getting the context. So I'm happy today he is giving us the context. Let's listen to him right now.
A notice of motion, which simply says that kindly take notice that an application will be moved on behalf of accused number 1 to the above Honorable Court for an order in the following terms. Number 1, that his legal representative be granted a further postponement to continue and finalize his preparation in the matter. Number 2, further and alternative relief. The factual background, that's paragraph 5. I've been part of the case representing accused number 3 since inception before the Honorable Mokgwatleng J. After the passing of Mr. Ngomezulu, who was representing accused number 1, I was approached by the Office of Legal Aid South Africa with the request to take over and continue to represent accused number 1. I duly accepted the request, and I formally came on record as accused number 1's legal representative on the 8th of January 2025, a provisional date on which the legal representation of accused number 1 is to be confirmed. Paragraph 6. The matter was then postponed to the 20th of January 2025, which was the original date arranged for the continuation of the matter on merits. This time, the witness who is currently in the witness stand was being cross-examined on behalf of accused number 5. That cross-examination was concluded on the 22nd of January 2025. The matter was then postponed to the 10th of February 2025 to give me time to prepare. And this time the state confirmed by indicating that the record of the evidence stands around 40,000 pages. Paragraph 7. On the 10th of February 2025, the matter was before court again, and I made an application for a further postponement as I was not yet done with my preparations, and the application was granted. The matter was then postponed to 14 April 2025, and I made an undertaking that I would be ready to proceed on this date. It is unfortunate that I was still not yet done with my preparation and that thus not yet ready to proceed with the matter on this date either. The events of the 14th of April 2025. That's paragraph number 8. I arrived at court on this date and immediately conscientized all my colleagues, that's the state and the defense, that I was not yet ready to proceed as my preparations for the matter are still ongoing, and I request that we approach and I requested that we approach the Honorable Judge in chambers on this issue. In the Honorable Judge's chambers, at the introduction of my inability to proceed with the matter due to the fact that I was not yet done with my preparations, the Honorable Judge directed that I should put that information on record in court. Paragraph 9. When the matter was then called and the preliminary issues dealt with by the state, the court then invited me to address him on my application. I submitted that I had underestimated the amount of work I had to cover between 10 February and 14 April 2025 when I indicated that I would be ready by this day to proceed with the matter. And due to the fact that I am not yet done with my preparations, I was not in a position to proceed. Immediately after those introductory submissions, the court took over and dealt with the application, although I was not yet finished with my submissions. Paragraph 10. I never got to ventilate the issues which constituted the challenges in my preparations. Neither did I got to indicate how much field did I already cover and how much is still left. I also could not indicate how much time were I requesting to finalize my outstanding preparations. When the court, after having heard submissions from the state and remarked that I was abusing the process or system, and that I never came across an experienced advocate as myself who was unable to read and complete 40,000 pages in 2 months, he went on to suggest the date of the 22nd of April 2025. It was at this point that I stood up and requested indulgence and told the court that I would still not yet be ready by this date, and if the court were to insist that a matter should be proceeded with, despite the fact that I would not have completed my preparations, I'm going to request to be excused from representing accused number 1.
And yeah, last week it was painful and sad when Advocate MNISI was belittled by the judge, saying he has never seen such, that a senior advocate cannot read 40,000 pages. It was, and the way he dismissed him, sit down, sir, you are abusing the system. And people were up in arms saying, MNISI, he's incompetent, he's forever looking for postponement, and he is an unprofessional, he lacks ethics, and the judge is so lenient towards MNISI. Kanti people, context is very important, and comprehension goes hand in hand with that. And let's take a listen on Advocate MNISI explaining and detailing how complex his work is. It's not just about reading, okay? It's not just page 1 to page 120, but it's more than that. It's complex. Let's take a listen.
Paragraph 11. The final decision was that the matter will have to be proceeded with on the 22nd of April 2025. And that accused number 1 will have to intercede in the circumstances if I would still not be prepared. Paragraph number 12. The cause of my preparation of the matter does not only involve reading, it also involves analysis, constructing and comparing, formulation of issues and arguments, research of applicable and relevant authorities from the legal literature. The list is exhaustive. Paragraph 13. Furthermore, the cause of my preparation in reading the record is also characterized by the fact that the record itself keeps on referring to other parts of the records which would have been previously dealt with, and to refresh my memory and to confirm those parts of the evidence being referred to, I am compelled to go back to those parts of the evidence on record being referred to. Paragraph 14. Similarly, the record will refer to some exhibits which would have been dealt with in other parts of the record, and again to confirm and to refresh my memory on those aspects being referred to, I am compelled to have regard and revisit those exhibits being referred to. For instance, I'm reading the proceedings of the 24th of October 2024, and the evidence referred to as an exhibit on the proceedings of the 23rd of January 2024. I would have to go and revisit that aspect of the evidence. These are some of the aspects which make my preparations tedious. Paragraph number 15. Having spent 2 days at Morabi Correctional Facility consulting with Mr. Sibiya, a number of issues came up which necessitate further follow-ups, which do not form part of the record of the transcripts, and thus the preparations are not necessarily limited to the record. The suggested period of 2 months within which I was expected to finalize my preparations does not factor in these extraterrestrial issues. Paragraph number 16. It also emerged from the consultation that we'll have to request further information from the state, which is central to accused number 1's case and to my preparations, even before I can start to cross-examine the current state witness. These are all the aspects which I intended to bring to the attention of the court, had I been afforded the opportunity to do so. Paragraph number 17. When the state was requested to respond to my incomplete application, it rationalized the importance of a further postponement, taking into account the nature of the preparations that I needed to do and acceded to the reasonableness of such an application. The state cannot be faulted on anything it said in its response in this regard. Paragraph number 18. It also emerged during my preparations that I was not in possession of all the transcript of all the proceedings in the matter. I requested on an occasion or two assistances from the former court registrar for assistance with those transcripts. I managed to get some and some not yet. As I'm preparing this application, I still do not have the records of the proceedings for the year 2025, without which my preparations will still not have been complete. The last communication that I received from the current registrar in respect of the records of the transcript was on the 21st of January 2025, and these were the transcripts up and until the last term of 2024. Paragraph number 19. I am very mindful of the fact that justice delayed is justice denied. And this applies mutatis mutandis. I would therefore not have embarked on a scheme to willfully delay the proceedings or hold them at ransom. I am perfectly aware that the accused are going through agonizing time with the trial hanging over their heads like a sword. They are keen to know their fate in the matter. The same principle goes to the family members of the deceased and all the people who take interest in the matter. I can, however, assure that there is not even the minutest iota of malice in the manner in which I am trying to conduct this case on behalf of Mr. Sibiya.
Now, after listening to this, you tell me if Advocate MNISI is not ethical, if he doesn't care about his client and everyone who's around, like family of the deceased and South Africans at large. Tell me if he's not, because I would want to understand people who are saying he's incompetent. Would you like to be represented by a defense who will just give in when he's being pressured just to rush in and just to please the court?
Paragraph number 20. In criminal proceedings, any suspicion of delay or any suspicions of delays are regulated by Section 342A of the Criminal Procedure Act number 51 of 1977. These provisions prescribe the manner in which such delays should be investigated, what constitutes delay, and its effect on the stakeholders in the trial and the mechanism of dealing with such delays. Paragraph number 21. While trying everything that I possibly can, I am and should always be mindful of the fact that the accused entitled to a fair trial, which include, inter alia, a right to legal representation. I am thus willing to proceed to assist the accused in the conduct of this case. This should, however, be understood in the context that a proper preparation is a cornerstone of the realization of that right to legal representation. Number 22. That's paragraph 22. On the 25th of April 2025, at 16 hours 15, that is 4:15 in the afternoon, the state sent me an email with a set of photos with the following message. We, open quote, we have extracted the attached photos from the phone downloads to be used as evidence, close quotes.
Listen to this. Nazo, new evidence again. Batung. What are these called? It just want a conviction, that's all.
Above the preparations that are already ongoing, although not yet finalized, this aspect of the new evidence should also be factored in the preparations and be considered in the totality of the whole body of evidence led thus far to formulate a challenge to it, if there is any. Paragraph 23. Although I have been part of the matter since its inception and has been following the trajectory of the evidence, that does not translate to the fact that I know each and every little aspect of the case and the evidence which has been led thus far against accused number 1. I have never consulted with him before. I've never received any instructions from him before, and never have I given him any legal advice before. In fact, I started to realize that there's so much that I did not follow in his case, not this, but in his case, when I am preparing this matter as his new legal representative. Paragraph number 24. It is very difficult as a legal practitioner to represent an accused who's facing a potential life imprisonment on the basis of the charge or the charges that he is facing, to prepare the defense of his case with the feeling that a gun is being held over your head and are expected to do things out of the ordinary. This takes away the creativity, spontaneity, and the art of independent thinking in the conduct of his case, and this does not resonate with the right to a fair trial. Paragraph number 25. In the circumstances, I respectfully submit that any form of pressure exerted on me to be prepared to proceed with the matter on the 22nd of April 2025 will not yield the desired results of affording the accused a fair and dignified trial as required by the Constitution of the land. As I indicated before, I could have underestimated the amount of work that I had to go through in the preparation of accused number 1's case. I respectfully submit that if this is to be held against me, it was inadvertent and without any malicious intent. Wherefore, I humbly pray that my request for extension of the time for the preparation of the matter on behalf of Mr. Sibia be granted as per the notice of motion.
As for me and my family, I would rather be represented by someone like Advocate MNISI, who is thorough, who take pride in his work, who looks out for the rights of the person that he represents, who's not rushing just to please the court and succumbing to pressures. He takes he's confident and he knows that he cannot be dilly-dallying with his work, because the legacy of his work will follow him. And I think we have learned that better justice be delayed than to convict people who are innocent. So, members of the bench, thank you so much for tuning in. Remember to like, most importantly, subscribe and comment so that this video can reach like-minded people. Thank you so much. Until the next one. Bye.